Judgment in the appeal of the Queen and Ahmad and Queen and Field.
Lord Tilson will explain the judgment of the court.
The Proceeds of Crime Act 2002 is a difficult piece of legislation. We are concerned in these appeals with the part of the Act which deals with confiscation proceedings after a person has been convicted. There is no problem in understanding the broad aim of this part of the Act, which is to deprive criminals of the fruits of their crimes. But the detailed provisions of the Act and its statutory predecessors have led to difficulties in their interpretation and application, and to many appeals. These two appeals are the latest to reach this court. They concern the proper approach for the court to adopt, where a number of criminals, some of whom may not be before the court, have between them acquired property or money as a result of or in connection with committing an offence for which they or some of them have been convicted. In the case of Ahmad, the appellants committed a very complicated and elaborate carousel fraud in which the revenue was defrauded of a large sum of money by a series of supposed transactions involving the import and export of computer programming units. The transactions were fictitious, or largely fictitious, but they involved a complex trail of paperwork and money movements. Such were the intricacies that the confiscation proceedings took 6 weeks before a High Court judge of the Commercial Court. He found that the appellants jointly obtained a very large sum, and confiscation orders were made against each of them for the full amount. On appeal to the Court of Appeal Criminal Division, the sum assessed by the judge was reduced to £16.1 million after allowing for inflation, but the appeals were otherwise dismissed. The case of Fields and others involved a different form of fraud on a lesser but still significant scale. The appellants were found to have obtained jointly sums amounting to £1.6 million adjusted for inflation, and confiscation orders were made against the 3 appellants for that amount. The orders were upheld by the Court of Appeal. Both groups of appellants now appeal to this court. They do not challenge the quantification of the aggregate recoverable amount or the findings of the lower courts that in each case they obtain that amount jointly. What they challenge is that each should be liable to pay the whole of that amount. The challenges take 2 different forms. In the case of Fields and others, where it was found that the 3 appellants jointly obtained a total benefit amounting to £1.6 million, and confiscation orders were made against each of them for that amount, it was argued on their behalf that the benefit ought to have been apportioned between them, and that the confiscation orders against each of them should have been for 1/3 of the total amount. In the case of Ahmad, where there are 2 appellants, it's accepted that it was proper for a confiscation order to be made against each of them for the full amount, but it was argued that the orders should have been made subject to a cap so as to prevent double recovery. The court unanimously rejects the argument that there should have been an apportionment of benefit in calculating the amount of the order, but it accepts the argument that there should be a cap to prevent the total benefit being recovered twice over. The reasons for the court's decision are explained in a judgment authored by Lords Neuberger, Hughes and myself. In short, the apportionment of benefit argument is a rerun of an argument made to the House of Lords in the case of Green and rejected by the House on that occasion. The fresh argument has not revealed any fresh points, nor has the earlier decision presented the courts with difficulties in understanding and applying it. On the contrary, it was consistent with a line of previous authorities and with the practice of criminal courts throughout the country. There is a proper analytical foundation for the decision, applying the ordinary meaning of statute, and to change it would be likely to cause serious practical problems in cases well illustrated by Ahmad for the reasons explained in the judgment. The court does not depart from its previous decisions or those of the House of Lords unless there is a compelling reason, and there is no such reason in this case. The cap argument is a fresh argument, and it has force. To recover the same benefit twice is to go beyond the underlying purpose of the Act. It would also infringe Article 1 to the first protocol to the European Convention on Human Rights, because it would not serve the legitimate aim of the legislation and would be disproportionate. The solution is that each confiscation order should contain a provision that it is not to be enforced if and to the extent that a sum has been recovered by way of satisfaction of another confiscation order made in relation to the same joint benefit. The objection was made that this could produce inequality of outcome between defendants, but that possibility is an inherent risk if people engage in joint criminality. The enforcing authority can proceed against whichever defendant it most easily can, and there is nothing wrong in the court allowing the loss as between the criminals to lie where it falls. For those reasons, both appeals are allowed to the extent that the confiscation orders will be varied in the manner just described.